Today's episode of Retired Life Wish You Were Here is brought to you by Pool Engineering and Surveying. Planning for retirement isn't just about where you live, it's about building a future with confidence. And when community and homes and developments are designed thoughtfully from the ground up, that future becomes possible. Pool Engineering and Surveying has been helping shape communities across the Florida Panhandle for decades, working with developers, municipalities, and builders to design infrastructure that stands the test of time, just like the plans you're making for your own future. To learn more about Pool Engineering and Surveying, visit pool-eng.com. Building communities, supporting legacies. Welcome to Retired Life Wish You Were Here, the podcast where we explore what retirement really looks like. The adventures, the transitions, the planning, and the unexpected lessons that help us live the next chapter with purpose and confidence. I'm Kim Lee, and this is Stuart Lee. And we're talking about something that many of us know we need, but we don't always take care of: estate planning. Now, this topic isn't about preparing for the end of life. It's about protecting your independence, reducing stress for your family, and making sure your wishes are honored. Joining us today is someone who helps families navigate one of the most important and sometimes misunderstood parts of retirement planning: the specialization in wills, trusts, probate, and helping people make sure their affairs are organized and legally protected. Welcome to the show.
Owen, thanks for coming in today and helping us learn more of what we think we know, but don't really. What is estate planning?
Yeah. First of all, thank you, Kim, and thank you, Stuart, for allowing me to be here. They call it an estate because it's after you pass, but it's really just your property and the disposition of that. And everyone has some piece of property, a money account or whatever. So don't let estate throw you. It's really property distribution after your death is a better way to look at it, I think. And the most important tool after death, of course, is the will. But it's so important to take care of things while you're alive. And there are powers of attorney. And just really the most important thing there is finding a loved one or a friend that you really trust with everything to take care of that. The old way was a power of attorney that stopped when you became incompetent or couldn't handle your affairs. But Florida's passed what they call a durable power of attorney, which has special provisions that do not terminate when you get incompetent or can't handle your affairs. And that's the kind of power of attorney you want. The power of attorney I prepare for most of my clients is very detailed. It even talks about has the right to write checks, deposit checks, make contributions, everything. It names it all so that, if a bank says, I'm sorry, this doesn't say that you can withdraw money or something, my power of attorney does that. Most attorneys have something like this. They also have a provision for a health care surrogate, so that person can take care of all your needs. I've had a case where a friend of mine, an elderly friend, she named me that person. And I got to decide her burial and everything. And this was back probably 30 years ago. But the doctors would not, and the funeral home would not allow me to make the decisions. They wanted to find some distant relative of hers in Hungary. It took 2 or 3 weeks. So I think that's all changed now. I think the healthcare surrogate business has gotten to a point where, they do recognize it, and you can name a friend to make those decisions. They typically want to know what loved ones think, family members, because of liability purposes.
So like a lot of people think that their belongings and stuff will just go to who they want it to automatically.
Right.
So can you explain what sometimes happens if you pass without designating this person? Like just give us the blunt. This is what's going to happen if you don't have your estate taken care of.
Well, a lot of people call me and say, I need a will. And I say, why do you need a will? because I'm not in the business of just doing wills for people. I want to know what their needs are. And if you don't have a blended family, in other words, if you have two children and your husband or your wife are the parents of both those children, then the statute really pretty much takes care of it. If you don't name by will who you want to have things, your husband's going to get or your wife is going to get your estate. If you have the same children, but when one of you has another child, it doesn't work that way. The spouse, the surviving spouse, would get one half the estate, and the other half would go to your child. The reason for that, the statute presumes that if you have a spouse and your children are the same with the two spouses, you know what I'm saying, that the surviving spouse is going to take care of those children because they're of his issue,
Right.
or her issue, and they're going to pass that along. And if they don't want to do it exactly evenly, that's just what parents do. But if you have, say, the wife has another child by someone else that's not in the picture all the time, that surviving spouse may not take care of that child. So that's the reason why the statute's that way. If you have a blended family, you more than likely need to have a will to specify how you want to do that. There's several methods, and one employed regularly is a joint will, where you actually enter into a contract with your spouse. Now, this is, say a second spouse or something, of how you want your estate to be distributed. And you both agree, here's the plan we want. And we both agree that we're going to carry this out. The key feature there is you have to disclose all your assets to your other spouse. You can't say, okay, let's agree to do this with this property, but you've got a $100,000 account over here that you didn't mention. So that would just destroy that joint will. But joint wills can work, and they do work. I know of a couple that the mother has the spouse, the wife has a child, the husband has no children. He wants to leave his money, maybe half of his money or a fourth of his money, to some institution or whatever. So what would happen there is that when the first dies, it all goes to the survivor, and the survivor has use of those funds, all of it, until the survivor dies. And then when the survivor dies, the personal representative that you both appoint is going to be somebody independent usually, or even a child, would then make sure that the wishes of the original will are taken care of. And you can't change that will. You can enter into a joint will, and either party can revoke it as long as neither party has died. But as soon as one dies, then that becomes a contract. You can't change it then.
So will or trust? What do you think? What's the difference, and why would you get one or use a trust? Or do you need both of them?
Well, trusts were really popular when the estate tax was like $60,000 when I started, back in the 70s or whatever. But now the estate tax doesn't kick in till $13.5 million. So most people don't necessarily need it. But I was talking to somebody recently, and I said, well, you don't have to worry about that because it doesn't kick into $13.5 million. And the guy started scratching his head, and he thought, well, maybe I do need it. So you never know who you're talking to. Mm-hmm. But generally, if you're over the $13.5 million, you're going to have your ducks in order, and you're going to need an attorney to probably set up an estate so that you can minimize your taxes. And there are ways. I don't want to get into detail on that because there's a lot of other things to talk about. But if one spouse has all the money in their name and they die and leave it, and they don't take advantage of their credit with the federal government, and they leave it all to their spouse, and then when the spouse dies, she gets her credit, but you could have used his credit and her credit. You follow me? Mm-hmm. Against that tax. So your children would benefit greatly by evening up your estates so that both of you have very similar amounts of money. But there's got to be a trust factor there, between the two parties.
Yeah.
Why do you think people delay doing estate planning?
Well, they don't want to deal with lawyers. They don't, and I can't blame them very much. And they think it's very expensive, but there are a lot of lawyers out there that are certainly able to help you. and you need to just have somebody that recommends a lawyer that you can trust. And generally, I have a questionnaire that just lays out the questions I'd ask you. And if people want to go online, they can get these kind of questions. But I tell people, just like you have a little book for your passwords, you should keep a little book of all the properties that you have. And if you don't have very many, then your book only has a page that says, I own my home, I own a checking account, and I have 100 shares of stock in something. But if you have that down, and you also say in your little book, I own this with my wife or my husband, I own this with a friend, that kind of thing, it's easy to go talk to a lawyer and tell them what you got, and they can say what you need, from there. The most important thing is to take a little step and just list your property so that when you talk to someone, because that's the first thing they're going to want to know. And they generally want to know what's the size of your estate for tax purposes. But like I say, I never really get into that anymore because most of my clients don't have that kind of money that it's worth, that they need to know.
So you mentioned going online. Do you think those are good?
What I was thinking is just you could go online, not necessarily do a will, but just to find out the kind of questions and how to prepare for it.
Okay.
Like probate preparation or something. Do something like that.
Because I think they have online.
You could.
You can do your own will or something. But we've definitely had an attorney work with us. But
we have a 3-inch thick 3-ring binder.
Right.
Because there's a lot that goes into it.
There's a lot that goes
real
into
in
it.
depth.
Yeah, where you've hidden everything, which I can't even remember.
Where you what?
Where I've hidden everything.
There you go. It's like your passwords. You keep it private.
Yeah. I've got 6 pages of passwords, and there's a lot of lines drawn through them where you have to keep redoing them.
Yeah. I think an important issue also is homestead because people many times don't understand it. But your homestead is the greatest protection you can have. And Florida is one of the few states that grant it. It's not homestead exemption. It has nothing to do with that. But your homestead is the property that you live in that's protected from creditors. So if you have a lot of creditors out there, and it's a nice idea to buy a big home and put all your money in it, and pay, keep your money in that home because nobody can come after it. But in Florida, the home passes to your heirs, to your children basically, or to your spouse. What was I going to say? I lost my thought there. Unless you change that. In other words, if you don't want, say, 2 of your children to have it, then you definitely need a will. That's a good point where you need a will. I don't want this child because this child has made a fortune, in this economy, and my other child has handicap here or there or something like that, or got married early and doesn't have the resources or that kind of thing, and I want this child to have my home, then you need a will to spell that out. Otherwise, that homestead property is going to pass right to all your children.
Both of them.
Yeah. And in the nice thing about a homestead too, in most counties, all you have to do is petition the court for, it's called a determination of homestead. And you just state who your heirs are, or who the deceased person's children are, or spouse, and whatever. And you say that they own this property, and that's where they lived when they died, and it should pass to these people, and you can file an order with the court and get an order determining homestead, and the homestead's done. It's not in probate. It's not subject to creditor claims, and it's an easy process. Duval County is one of the counties where I ran into a real problem. They made me open an estate to file for a petition for homestead, and I've never had another county do that. And so my client had to go through probate in Jacksonville to get the homestead that that she was entitled to from the beginning.
So do you want to explain a little bit about probate?
Yeah, there's summary administration and there's formal administration. Summary administration is for estates under $75,000, which is what most people, because when I say that's not a lot of money, but so many people have so much of their assets jointly owned. Anything that you can name a beneficiary upon, like insurance proceeds, even money market accounts, pensions, retirements and all, where you name a beneficiary, all that passes what they call operation of law. In other words, it just passes to the person that's named as a beneficiary without going through probate. So a lot of people come to me and say, I own everything with my wife, my husband, so therefore do I need a will? And you go, no, because nothing's going to pass by your will. It's all going to pass by this, who you name beneficiary. It can't hurt to have a will because sometimes you forget something you had, and you might just have a short will that says anything I haven't already disposed of by naming a beneficiary, I leave to X or Y or something like that. Probate, like I say, there's summary administration, there's formal administration. Summary is fairly simple. You just file a petition. You state who your creditors are and everything. You don't have to put a notice in the paper, and you'll get an order of summary administration. That beneficiary gets those assets, and if you don't advertise or whatever, and someone comes in later and says, hey, your mother owed me, $5,000, then you would be liable for that $5,000. But you're never liable for more than what you received. You know what I'm saying? Mm-hmm. In other words, she had a $20,000 debt and you only got $5,000 in her probate, then you would only be liable for $5,000. But you can take a summary administration and put it in the paper and give notice that there has been a summary administration order issued, and creditors have 3 months. And if they don't come in, then you're free to use those assets as you please. A lot of people are afraid of formal administration. They think probate's terrible. I tell people probate can be your friend because a lot of times a bank won't deal with you, a stock company won't deal with you, that you will never be able to get those assets that are not, disposed of without probate and a judge telling this entity to give you that money.
They won't even tell you what's in the account.
I know.
Yeah, I mean.
I really have trouble. My wife and I do a lot of dealings with banks and whatever, and I just count on getting a good cup of coffee and sitting back and getting on the phone and dealing with the robots one after another until you get someone.
What are some of the financial consequences you've seen from families that didn't have an estate plan?
That's a really good question, and I can't impress enough. Oh man, because I've had some really tough cases where someone thought they did a good job. I've got a father that had a will. He wanted everything to go to his wife if she survived him. She didn't, so it was to go to his children equally. And then father starts loaning, say, the son or the daughter lots of money, and he's smart enough to get a promissory note, but years go by and he never encourages her. He never tells her she needs to pay that, or tells the son he never needs to pay that, or he just doesn't collect it and whatever. And then dad dies, and the child says, well, dad gave me that money. I mean, we did a promissory note because we like to pretend like it was business, but it was really a gift. Well, the other sibling is left out saying, nah, that wasn't it at all. This person got all this money, and now we're supposed to split the estate evenly? And see, Dad could have taken care of that by going and redoing his will. I mean, he had an attorney, and he could have just easily written up something and saying, I gave my son or I gave my daughter $150,000 in my lifetime, and I'm forgiving that, and I still want my estate split equally. Or they could say, I want my personal representative to collect that or take that into account when distributing the assets. That would have probably saved this brother and sister a lot of turmoil and a lot of just heartache between them.
I'm sure that stuff kind of hits families hard.
Some families aren't just planning for what you're going to receive. They're planning for someone who needs a lifetime of care and support. So they have a child who's disabled.
Right.
So how does estate planning change when someone has a special needs beneficiary?
Well, there are special needs trusts, and let's start from the basics. The way those trusts generally read are, I want to provide support for my child, but I do not want to cause any conflict with the benefits that she would get from Social Security or,
Oh, I
or
didn't
whatever.
even think of that.
Yeah. So you have to be careful. In other words, I just got into a case with this recently where the caregiver was asking to be paid because she had spent 10 years with this child and she loved the child. The problem was once you have a child for 10 years, if it doesn't matter who that child is, you fall in love with it generally. Even a bad child. This child causes a lot of problems. This child is banned from a number of places. But that caregiver really loves her and is going to take care of her. Well, the trustee of that trust knows that, but the trustee's not awful. They're just trying to make sure they comply with the terms of the trust, which are you are not to pay for specific care or something that might cause Social Security benefits to be disrupted or any other kind of benefit, but it's for special needs. That's why they call it that. Like, say, for extra clothes or for entertainment or things like that Social Security can't come in there and say, well, you're getting all this money, you're not in need for this money anymore. So we're going to cancel it. And that happens a lot now. It's really happened over the last 4 or 5 years where people are getting cut off of Social Security benefits and whatever.
Wow. I didn't even think about that.
Many retirees own property and businesses with partners, and you've touched on that just a little bit. Can you explain the difference between tenants in common and rights of survivorship?
Yes. Stuart, tenants in common might be you and I want to go into a little venture and buy a house on a lake because you want to use it for fishing and I want to use it for parties. And so we decide we're going to buy a house. We don't have any relationship, other than we're friends. But we go into this property, own it as tenants in common. That means you own 50% of the property. It's an undivided, you don't own any particular part of it. You just own an undivided 50%, and so do I. When I die, my share does not go to you. My half of that goes to my heirs by my will, or if I don't have a will, to my relatives, my descendants usually. Yours would go to yours. A tenancy by the entirety, and typically, Stuart, we could still have a tenancy by the entirety, or not tenancy by entirety, survivorship if we wanted to. In other words, we could both be really good friends, and I don't have anybody particular, and you've got somebody, but you don't really want to leave them that property. You and I could own that property with a right of survivorship. And that when I die, my interest would go automatically to you. That's very uncommon. But you always see husbands and wives owning property together. And when they own property, when you take a piece of property as husband and wife, it needs to say that too. Because some people, it just needs to say husband and wife. In Florida, that's called a tenancy in the entirety. And that has a survivorship feature. That property passes to that spouse upon your death. And that's another thing that passes outside of probate. And a lot of people own all their property, as tenancy by the entirety, or with a survivorship feature. They don't really need a probate so much, or they don't need a will because all their property is going to pass that way.
Well, with tenants in common, you need to make sure of who is going to inherit too. If you're going to be a partner with that person,
yes.
You may not want to be a partner or have a buy-sell agreement.
There you go.
Because
really good point.
That would drive me nuts to wind up with partners that you never intended to have.
That's why you don't see tenants in common very often.
Oh, okay.
But that's a really good idea. I mean, like you're right. Stuart might not want to be, a tenant And in that case, with my brother, because there's plenty of reasons for that. And you're right, it puts one at a disadvantage. I mean, Stuart's got to say, okay, I'll give you this much money. No, I'm just going to stick it up, keep you really confused here and not let you do anything with the property until you pay me a little bit more than what it's worth or something like that. So you got to be very careful, like with that.
What risks do business owners face if they don't understand how their ownership structure affects inheritance?
I don't really know how to answer that without a specific, but I can say when you're leaving a business to someone, you do have to be very careful. I would probably try to treat that. I'm not sure how you would actually structure the ownership of that. If we had an example, I might be able to help there.
Well, once again, you'd want to have some buy-sell agreements.
Exactly.
And because I have a family-owned business
There you
with mostly family, but we have some other employees who are owners, and so
Right.
that comes into
Right.
play.
Right.
Because if they pass away and they leave it to their family who is, not in the business or as a minority partner, it's not that big of a deal, but
Right.
still, there are things you might want to do with the stock.
Right. That sounds like a really good, and I haven't thought that out very well. But buy-sell agreements, when you're dealing with business, oriented assets, are
Yeah.
probably very likely.
Well, what about everyday financial commitments? Like the checking accounts, all that stuff. So somebody dies, the automatic bill payments, the investment accounts, the annuities and beneficiaries, passwords and digital access. So somebody dies. Number one, you got to find the will.
Right.
I wonder how many people don't have any clue where their family's wills are.
Right.
And then second, what do you suggest for someone to do as part of the will to help the whoever's going to come behind them as the receiver? What are some things they can do to help make this an easy transition? Does that make sense?
Yes. I think you should let someone in your family know, especially someone you really trust,
Yeah.
and probably someone that's going to benefit from the will. Where the will is always. And it can't hurt to have a few copies of it out there. And you can even say it's a copy, but I have the original, in my desk drawer. Because there's a presumption if you can't find their will that the person didn't like it right before they died, they tore it up.
Yeah.
And somebody that's left out of a will, might think that, or would rather it not pass by the will, but rather it pass, by the statute. So I'd get a share, but with a will, I won't get a share. So you got to be careful who gets into your house.
Every good murder movie can never find the will.
Exactly, exactly. And I've got a case right now where there's a missing will, and what I'm doing is trying to prove the will, which you can do. But there again, someone could come in there that was left out and say, well, the reason why you can't find that will is because Grandma or Mom tore it up because she wanted to put me in it, and she didn't have time to do a new will, so she tore it up. That's just going to get down to who's credible in court, and you don't want those kind of things. Lawyers used to keep wills, the original, and that wasn't a bad idea, but we got to a point where we didn't like it because we had all these wills, and it was too much of a responsibility to have somebody's original will. So we returned all those wills to people and made them sign for it and everything so they had it. But generally, I always say, the person should keep their will and make sure that you have a really trusted loved one that knows where that will is and can access it. The most important part in estate planning or all of this is having a person you can trust to take, to fill in for you. And that's a hard thing sometimes. Mm-hmm. That's a very hard thing.
What about, so like you've come up and you don't have the same assets. So you made a will out.
Right.
And you had a building. So you sold that building.
Right.
What do you suggest people do to handle that?
Well, that's called lapsing, and that happens often. And the written rule is, if the property isn't owned anymore, it's just you just strike through that paragraph in the will. It doesn't say because Owen was supposed to get that property I sold, and now I want Owen to get something else. Now you could say that, but most wills don't say that.
Can you write?
Oh,
Can
you can
you
write
do
it.
your own write-in?
Oh yeah, you can do anything in a will. Yeah, it's
Really?
just you can say anything you want. There's no standard procedure, and I have people that do it. Like if this happens, I want that to happen. I have a woman right now that lives in Mexico Beach, and and she's just got this. We have gone over and over the different possibilities of what might happen, and she's got a child that she wants to take care of, but she doesn't want to leave any money to because they can't take care of money, and it just gets real confusing. And so I've done a lot of creative writing. I think I've written a little novel on this will just from trying to write up. But you can write anything you want as long as it's in good English and people can understand it.
So what about with retirement accounts? Can you, I know that the spouse receives retirement unless they sign, they have to sign when you make changes.
Right.
So can you do the changes in an addendum, writing it out yourself?
I would say not, because retirement accounts are going to have a named beneficiary, and that's something that's going to have to be taken up with the retirement, whoever's handling those funds. But they would let you make some type of special beneficiary designation in those where you can. You mentioned checking accounts too, and that's a very important thing. I had a woman die recently, and she had a payable on death statement, or designation in her account. But the person that was going to get the money upon her death never knew about it. And the bank didn't take the time to call this person up and say, hey, we have $10,000 here of Mrs. Smith's money that she left to you. They're not going to do that. And you can't, they can't go to that kind of trouble. So you really need to know that you're on that account. And it's...
Well, what about, if a family has someone who's doing the power of attorney and they're on the account, they're on the account to make sure that their mother or father doesn't do anything, or if they're incapacitated, they can also write checks. What about those accounts? So the parent dies. What happens? Does the person who was the other signer do?
Good. That's a good point. Keep in mind, number one, a power of attorney dies with you. In other words, you have no power of attorney over a person that's deceased.
Unless you're durable, right?
No.
No?
That's only
No
when you
matter
become
what?
incapacitated and you're alive. But when you die, the power of attorney is no good.
So if you're on that account?
Now, that's different because I was, first of all, handling a situation where you're not on the account, but you have a power of attorney where you can write checks for her and everything else. Mm-hmm. So you can do that up until the day of death. Now, a joint account is a good idea, and that's another situation where you really need a trusted loved one to be on that account with you, particularly someone that, say there's $10,000 in this account and it's got your name on it so that you can pay bills for her when she's not able to and whatever. But your mother wants you to leave that to your children, all your children, not just you. But that money goes right to you. It's
Mm-hmm.
your account when she dies.
Got it.
But there's an equitable principle there that you would share it with the others. That doesn't always work.
No,
so you
I've
got to
had
be
too
careful
many
there.
Friends that,
Yeah. Well, what I would suggest is, and I always do this, you can have many bank accounts. I know they cost money to keep going, but that account that you have, say, that carryover account of $10,000, just so that before my estate's established, that my daughter can write checks for me and everything, you might put her on that account, but don't put a whole lot of money in it. Don't put $200,000 in that account. Keep it, something that she would have $10,000 after you die to write checks for this funeral bill, that kind of thing. And then if she doesn't want to split it with the other siblings or whoever else is your heirs or beneficiaries, then it's not a big deal. But it's always nice to have someone on an account like that. One thing I get into so much, and this happened with my own brother, he decided the best way to go is to have automatic debits and automatic deposits on everything. Well, when he died, it took me 6 months to stop all those automatic debits.
Oh,
They were going in an account, and he's got $10,000. Next thing you know, he's got $9,000. Next thing you know, he's got $8,000, and he's not using the service anymore. And it takes a long time to get the banks to come around.
yeah. You
do.
definitely don't want those on an account with very much money.
Some do.
So they at least run out of money.
Social Security is really good. You know, as a matter of fact, Social Security is works in combination with funeral homes. A funeral home has to notify, or I don't know if they have to, but they do. They notify Social Security right away, and like Social Security will stop an automatic.
They will suck it back out.
They will
within
suck
a
it
day.
right back out. I'm
They will
telling
put
you,
it in and shoo.
that's the only thing I think the government does efficiently.
Yeah. Now,
really-
I know they did my son he called me up and he goes, Social Security was in Dad's account and they took it out. They took it out. He had been alive for most of the month.
Yeah.
They took out the month that he.
Yeah, now that's true.
So
yeah,
they
I don't know they can
did
go back.
eventually put it back in.
Yeah.
But it was out so fast.
I think it's a good idea, but once you become, I don't know how to say it. Once you just realize you've reached an age where, you might not be, a year from now or being able to take care of things and all, stop those automatic debits and all. The automatic deposits aren't bad. You don't mind people putting money in.
Right for it.
You can pay it back some other time, but you don't want automatic debits to keep coming, And I think that's my biggest complaint right now with people that don't think ahead. And it's hard to think ahead on that one because it's so convenient.
Plus, you can just be driving out, walk out, and
Exactly,
drive down the road.
yeah.
You're dead, and your
Yeah.
automatic debits are.
Exactly. You can't do anything about that. We're only talking about things we can take care of here.
So, now while healthcare directives aren't your main focus, how do they connect to estate planning?
I don't think they do particularly. In other words, other than
You put it in your will? What you want people, what you want
typically
done?
not your last will and testament, but like I say, the power of attorney that I have has health care. Of course, any health care directive ends at your death, so there would be no reason.
But if you're in a coma,
right,
I
well,
mean,
that's when you're
leading into your death.
exactly. Well, up until your death, that person can have say over your care, and you definitely want. They call it a living will a lot of times, rather than I think.
Oh, okay, that's
really,
right.
in the last few years, they started calling it healthcare surrogates or things, statements like that. But it's a living will, and it just says, "Here's what I want to happen to me. If I'm in a position where I'm not going to come back, I don't want you to be giving me, life-saving, efforts or whatever. Just keep me with water and whatever." And everybody knows what that means. The statute actually covers it. So your last will, your living will, would actually refer to the statute, and the statute gives all these
They have a
situations.
questionnaire.
Exa-
So you don't have to make it up. You don't have to sit there and think. It's a questionnaire, and it goes, do you want, if you can't talk or breathe on your
Right.
own or any,
No.
what do you want to happen?
Yeah.
So, and they have each of these questions, you answer those, and that's your living will.
Living will.
Yeah,
Pretty
basically.
much.
But like I say,
You should do it.
everyone needs a living will for someone to make decisions for them. It's always going to be your spouse or one of your children. There again, you might have two children that have different
That really want to
ideas.
get rid of you.
Okay, I want her to live. I don't want her to live.
Okay, he's breaking the tie.
So I'd go with a living will. And living wills are very easy. And those are the kind of things, I don't suggest people necessarily just, blatantly go into something online and sign it, because you never know what you're getting into. But there's enough references out there that you should be able to find, a living will. And you can actually, research it in the Florida statutes. Just look up living will, and it'll tell you what doctors can do and what they can't do. Certain things they're not going to allow you to do. You can just say, I don't want her to get oxygen anymore. And no doctor's going to do that. And the statute doesn't require that. They just require that she be kept in comfort or he be kept in comfort, and just don't do any heroic efforts to save their life.
Yeah.
That's basically what it is.
Estate planning isn't about preparing for the end. It's about protecting the life you built, the people you love, and the legacy you want to leave behind. We hope today's conversation sparked questions or reminded you of things you haven't done yet or were meaning to organize, and consider this as a sign for you to start that conversation. Thank you for joining us, and thank you for joining us in Retired Life Wish You Were Here, where retirement is not the end of the story. It's the beginning of the next great chapter. And if you're enjoying watching our show, check out our Retired Life merchandise, because retirement isn't just a lifestyle, it's a badge of honor. And for you today, Owen, we have our bag, our Retired Life beach bag, ship bag, cruise bag, whatever you need this for.
Thank you.
And we hope you enjoy it.
Oh, I've enjoyed it.
And thank
very
you for
much.
coming on today. And if you like this episode, please hit follow and subscribe. Thank you.